No, that would suffer from a fallacy, you know.
Yeah.
Parliament's legislative authority is untrammeled in...
No, with respect, your lordship has held repeatedly.
That's why, as I said earlier, Chief Justice Venkatacharya called this ragbag legislation. No, when he was referring to the taxing legislation, he says ragbag legislation, which is traceable to a lot of powers which Parliament has, if not anything, 97.
No, with respect.
No. A UT cannot legislate to set up a service.
Yes, so UTs have no power about the Public Service Commission.
No, but Parliament has the power.
No, Parliament.
Because Dr. Singhvi, there cannot be a legislative vacuum in India at all. In any country.
This is a created...
Because there will be new subjects which will emerge, there will be unheralded subjects. Power has to exist somewhere.
Yeah, definitely.
No, but here what happens is,
yes,
Parliament has powers over everything.
No, with respect, everything in list 2.
Yes.
Not generally. No, with respect, Parliament becomes the UT in the state list.
Right.
It doesn't mean Parliament starts exercising in the UT powers under some other list. Argument is PSCs, Public Service Commissions, are not applicable to union territories per se. It's not about Jammu and Kashmir, Delhi. It is not about physical existence or absence. The concept of UT and the concept of a service commission is anathema, mutually exclusive. One doesn't permit the other. Unless we understand this argument, this is the argument which I am meeting, and it falls to the ground once you formulate in these stark terms. This is the argument. So, conceptually, your lordships can't apply a service commission to a UT. Ever, any case, any UT, Delhi, JNK, anyone.
That was the way his...
That is the reason why lordship's query is very important.
Formulated, but later on the solicitor sort of modulated it in his submission.
No, but therefore that's very important. That's why now your lordship's query can be answered only after I first formulate proposition. So please take this. This is not put like this in my submission. Lordship may do with the favor of noting it or otherwise putting it somewhere else. Conceptually, a service commission and a UT cannot coexist, is the argument. That's why it's inapplicable. That's why 41 is inapplicable. That's why there is no power. Point number 2. Well, sometimes things might sound simple, but from the simplicity, flows are good. If that is so, it is common ground that Mr. Mehta exercises power only over UT. As far as my case is concerned, Delhi or Jammu and Kashmir. If a concept of a service commission is anathema to a UT, how does Parliament exercise it? Cannot. We'll come to Jammu and Kashmir immediately. If conceptually the two are anathema, Parliament is today, Parliament oblique UT Parliament, if I may use that word. My lord is not considering Parliament in state and Parliament in Parliament. Your lordship is considering a third avatar of Parliament, Parliament with UT. If UTs cannot have service commissions, then Parliament cannot enact law. Parliament cannot create either the Public Service Commission of JNK or for that matter Delhi, because as my Lord Chief Justice noted in the opening, this is a argument applies across to UTs. No, all UTs.
The argument that would be really an unfair, assessment of his submission.
Yes.
He doesn't say that you cannot have a PSC or that you cannot have a service for a UT. The argument, for instance, he says, well, you have a service. You have the AGMAT services for UTs, for instance. The point is about legislative jurisdiction. His argument is that you can have a service, a common service for UTs, but it's Parliament's power to create that service. Likewise,
I'm coming to that.
Parliament's power to create.
Immediately, please.
He says entry 41 does not apply.
Therefore, that's C. I've done two.
But Parliament has no restricting.
No. I'll be dealing with 97.
Entry 41 not being available would prevent the state legislature, the UT legislature from enacting law.
So,
but Parliament is untrammeled because if Parliament has no specific power, in any case you have power under 246 code, you have entry 97.
So therefore, allow me to develop. So the argument is that UTs cannot have service commission power. Let's leave aside Parliament. UTs don't have?
No. A UT cannot legislate to set up a service.
Yes, so UTs have no power about the Public Service Commission.
No, but Parliament has the power.
No, Parliament.
Because Dr. Singhvi, there cannot be a legislative vacuum in India at all.
No,
or
no,
in
no.
any country.
This is a created.
Because there will be new subjects which will emerge, there will be unheralded subjects.
No, it's kind
Power has to exist somewhere
Yeah, definitely.
to legislate.
Whereas what is happening is they are creating a legislative vacuum. Now, I am not here reached 41 yet. Let's just bear with my first two propositions. The argument is that a UT with a service commission is anathema. Let's leave aside parliament. Conceptually, the UT doesn't have. And because UT doesn't have, then when you go to list 2, which the UT can enact over all the items of list 2, minus 1, 2 and 18, UT can't act under 41. Right, Malas? Let's leave aside parliament. So, Malas, first curious thing, UT can act under all legislations. There is no specific exclusionary article in the constitution which says UT can act under 50 list 2 entries, but not under 41. But by implication, UT cannot act. That's my third point. Now, what is the fourth point? Parliament could not have enacted either Jammu and Kashmir, or if it wants to try under Delhi, except under entry 41. Nothing else.
You know, Parliament.
Entry 41 is a direct.
No, that would suffer from a fallacy, you know.
Yeah.
Parliament's legislative authority is untrammeled in.
No, with respect, your lordship has held repeatedly.
That's why, as I said earlier, Chief Justice Venkatacharya called this ragbag legislation. No, when he was referring to the taxing legislation, he says it's ragbag legislation, which is traceable to a lot of powers which Parliament has, if not anything, in 97.
No, with respect, repeatedly held by your lordships, repeatedly, not once. 97 doesn't enter the picture where there is a specific entry in list 2. Repeatedly, that has to be, Malas. Otherwise, there will be no federalism. Malas, if 97 became, as your lordship put it, the ragbag, then there will be no federalism because list will be swallowed up.
Dr. Singhvi, there also there's a problem with the argument. I'll tell you why. This will apply where there is a specific entry which confers exclusive legislative jurisdiction on the states.
Yes.
All right. So for entry 18 of list 2, land, that is say land tenure, land revenue, etc. So Parliament cannot exercise power under entry 18.
41, Malas. Direct entry.
No, but here what happens is Parliament has powers over everything.
No, with respect, everything in list 2.
Yes.
Not generally. No, with respect, Malas. Parliament becomes the UT in the state list.
Right.
It doesn't mean Parliament starts exercising in the UT powers under some other list. But it's the whole idea, your lordship judgment says so.
But Dr. Singhvi, Parliament, even in relation to a UT, can exercise powers under list 1.
Under the entire list 1, it always can. List 2 is available to Parliament. There's no point of having a UT.
The power to set up a public service commission within a UT can be traced to entry 97. The rest of the
entry can't because entry 41 occupies. No, with respect.
Article 248
Mr. Jain.
is a restitutory power.
Right. The moment, let me. Now,
Article 4 is.
Please appreciate this. Your lordship is not considering a situation where Parliament chooses to pass a public service commission law for Delhi. Nobody is saying they can't pass.
That's
what my lord is considering is.
No, we were therefore saying
that your lordships cannot have the power of the state, that is the UT legislature, to deal with 41, despite Parliament not having exercised. Now, in that a subsidiary point came in, that where is Parliament's power traceable to? Your lordships, in fact, formulated the question in one way and then said if there's nothing, it will be 97. There is nothing, is the gap in the reasoning. It is assuming what is sought to be proved. There is something. There is entry 41. No entry can be more direct than 41, Whereas your lordship, the constitution bench, have said 10 times.
There are two questions really.
And your lordship has said
one, can the Delhi legislature set up a state public service for Delhi? One.
The answer is yes, but your lordship will go on.
Two, assuming that the power is not given to the Delhi state legislature, can it still exercise executive authority over the area?
Answer to both is yes, because the answer is yes in the first case, therefore the answer is yes in the second case. Give me a minute. Just take a concepts are most important in these things, not the minutiae. Take the list 2. It is common ground until you come to 41. There on every item of list 2, Delhi Assembly sitting in Delhi, it is passing laws. Every day it is passing laws, every item of list 2. Forget 1, 2 and 18. I'm not talking of 1, 2 and 18 and 16.
Does the enactment of part 14 take away that power?
That was separate. Allow me to come. There is a very strange proposition is told to your lordships. I don't want to deal with it now. that Prem Kumar Jain says part 14 and 312 will apply. In the same chapter, same part, same section, 309 will not apply. It's the most remarkable reading of context in the Constitution. Please leave it aside, I'm coming to that. People forget, my learned friends have forgotten, that Prem Kumar Jain was on part 14, which has both 309 and 312, 3 sections apart. Same chapter. Your Lordship has 1,000 judgments that unless some extraordinary words of the Constitution say your Lordships can't apply X to 312 and Y to 309. But well, let us leave that aside. It is common ground that in every entry of list 2, we are suddenly told that without pointing to your Lordships any article of the Constitution, you can't do it in 41. Now remember,
Dr. B, is there any other entry in list 2?
Yes.
Which conceivably it could be argued is not applicable to a UT?
Exactly. I took your Lordship almost 3/4 of the way down.
Right.
I read about 40 entries or 35 entries.
Right.
Well, once your Lordship's 239 AA chooses to exclude 6 entries, why will your Lordships at all go down the path of being told to imagine that some more are impliedly excluded? Well, these are fundamental principles of interpretation.
Or is the word insofar as is applicable really intended to be a word which says with such
Mutatis
mutandis?
Well, as I argued with you, well, it is nothing but mutatis mutandis. It fits in perfectly.
So far as may be applicable means
well, it
mutatis mutandis.
Greatest humility.
That's your
it's intended to mean mutatis mutandis because we are dealing with a sui generis creature. Once your Lordship takes that view, it harmonizes everything. Now allow me one more thing. So my Lord is today being told that 41 being as it is directly dealing with the subject. I am right here and now saying for the 10th time, if Mr. Mehta chooses to pass a law on 41, your Lordship will be dealing with a different situation. What is the problem? Having not passed a law in 41, having passed no law in 41, why is he going back to 97? Note that judgment, Justice Rumapal put it very well, but in that judgment. Give me that. There are any number, it has to be. Otherwise, if you use a residuary entry to trample over list 2, there will be no federalism left. Now, kindly see that. Give it to me. Line it. I'll just give you a lot of That brings me to the 4th aspect. You are Parliament. You have admittedly a UT. Well, this is an example of being hoisted on your own petard. You have a UT. You have enacted a law, but when faced with the direct of a Public Service Commission for a UT, and your Lordship in the opening asked me, UTs include Delhi and non-Delhi. So it can't be a law that UT means different for Delhi and UT means different for Jammu and Kashmir, as far as the concept of UT is concerned. Now, how did you enact a law except under 41? When your Lordship put that question, the answer is no, I elected. First of all, there's no answer. Your Lordship gave, if I may say so, both sides of the coin. If you did not do under 41, the only power is 97. Because of course, we would not expect. Is itself indicative of the fact that this is how the Government of India stand. Not that there is any estoppel here. Nobody is arguing any estoppel in constitutional law. But your Lordships can take it. The Government of India has never dreamt of 97.
No, but the power is there. There's the constitutional
right.
power is there. Then
now just see 41.
From the judgment in Dillon, it has been always said. For Parliament, you only ask whether there is a subject in list 2. If it's not in list 2, then of course.
Now just see list 2. 41. There cannot be words more directly occupying. State Public Service, semicolon, State Public Service Commission. But there can't be more direct words. Your Lordship has held by implication entries to occupy with much lesser words. My Lord is absolutely right. Absent 41, you might, I'm not conceding, because I doubt if a Government of India, which is given by your Lordship's constitutional bench power to act for a UT under list 2, can start acting under list 1. That is another thing. Your Lordship constitutional bench makes it clear that the difference between a regular state and a UT is that Parliament can act on list 2 subjects. Now, suddenly you go to 97, On general principles, it's not allowed. Let's kindly see the judgment.